All right, Mr. Bucicchio, you're here on the Astera Credit Union versus Johnny Goss case.
I am, Your Honor.
All right. So we're on the record in docket 22-02465. That's Astera Credit Union versus Johnny Goss. Will the parties please introduce themselves for the record?
Good morning. Bucicchio on behalf of Astera Credit Union, P62076.
And sir, you are Johnny Goss?
Yes, Johnny Goss.
All right. This is the time set for a motion. If I remember, I have not dealt with this file. This went to the chief judge. There was a question on some of the service fees concerning the default judgment and whether there was proper notice given at that. It looks like Mr. Goss received notice of this hearing because this is for default judgment. So Mr. Goss was not present at the initial hearing, which the default was requested. Is that correct, Mr. Bucicchio?
Your Honor, I believe there was some issue as to whether, or the court had some issue as to whether or not service was provided. And if I recall correctly, I believe we did submit a proof of service on that, or that Mr. Goss otherwise had notice of this. I believe the addresses are the same with respect to this notice here. And Mr. Goss, are you suggesting that you have a new address now?
Yes, this I got this notice. This is the only notice I got, and it got well, no, yeah, I do got my new address on file on this court paper, but this is the only notice that it was forwarded to the new address, my new address. So this is the only notice I ever have received.
What's the new address?
You got it on file on this court paper, the 5414 West Michigan Avenue, Lansing, Michigan, 48917.
Apartment 304.
Yes, sir.
And that's the same notice that the alternative notice was provided to that 5414 West Michigan Avenue. The hearing, but you're indicating that service was tacked or securely affixed by copy of the documents on that address, and by mailing a copy of first-class paid postage to the recipient at that address. So those were the two ways that notice was provided. Was I have by service by alternative method. That wasn't the issue of the hearing. The issue of the hearing had to do with the proof of service and some of the fees. But Mr. Goss, now you're indicating, and you've appeared at this hearing, that you never received that tacking or securely affixing a copy to that address or by mail.
No, this is the only notice I have ever received.
I'm sorry, I didn't understand that.
No, no, I haven't. This is the only notice I've received that I have received personally in my mail.
You're right. The file
go ahead,
showing that the alternative service methods were accomplished.
Yeah, I also have that, but that's why the hearing was set, because there's some fees associated with that proof of service that seem to be questionable. But now,
what are you about, Your Honor? The professional fees or the service fees?
It is there's 40 miles traveled for service is charged, and that seems to be much more than the 3.9 miles that we have from our civil department. And then there's an additional alternative service preparation with an additional $40. That's what the chief judge saw and said, please set for hearing to enter judgment. On both of those fees, I need those explained on some level. They don't make any sense to me. But now I'm questioning the whole proof of service. Now I'm questioning whether that Mr. Goss receive proof of service on this?
Your Honor,
There's a service miles traveled is 40 miles. We have it at 3.9 miles. And then there's an affidavit alternative service preparation, 40 miles, an additional 40 miles. I don't know where that comes from. And that's 49.30. So that's that same amount plus $10.
Your Honor, I can't speak to the court officer's affidavit. What I can do, Your Honor, is I can look into it and we can adjourn this until I investigate that. That doesn't sound right to me either. But again, we take the court officer at its word that the affidavit they file is correct, but we can look into that and determine whether or not, that's correct. Alternatively, Your Honor, if you'd like to just back out whatever it is, 4 miles or 3.9 miles, whatever it is, then we can do that well. I can't speak to what the court officer submitted here, Your Honor.
All right. Mr. Goss, I have all the paperwork indicating that service by alternative method was issued by was not only tacked to the front of that apartment, but also mailed first class to your address. So unless you file a motion to set aside this verdict, this default, I'm uncertain how to proceed other than to indicate that you received service of the date in question, which comes out of April 24th. Well, it was served on April 24th at 5:30. I'm gonna indicate that your failure to appear on the default.
If I would have received
Was
notice,
signed-
I would have showed just like this one. I would have showed. I mean, why I'm gonna show up to this one if I got this one in my mailbox? I would have showed up because I don't got no problem.
I can't answer that, Mr. Goss. I can't answer why the mail worked one time. It also the box is checked that it was tacked and affixed to that apartment 304 address.
No, I didn't ever receive no notice.
So you not only were mailed, but it was tacked or securely affixed with a copy of the documents, and then you failed to appear. So at this point, I guess I'm willing to let the lawyer. This wasn't a default set aside verdict. If you want to file that, Mr. Goss, you can to set aside this verdict for lack of notice. But that's not why we're here today. Why we're here today is because this was set for hearing because of the excessive mileage and the affidavit for alternative service preparation, which we set it to see if there was something we didn't know about. To see if there was something that we didn't know concerning the process server. And I guess part of this is I'm kind of interested to know what I think it's Christy Richards is the process server. What the reason is. If that's a mistake, I understand. I don't know what the $40 and the plus 10 for affidavit of service preparation. So I'll leave that, Mr. Bucicchio, to you if you want to investigate that to see, or if you want to go ahead and resubmit an order with the amended amounts. That'd be fine too. That was the purpose of the hearing. That did make sense to one of our judges and the civil department, and that they went ahead and said, please set for hearing to enter judgment.
Yeah, I understand that, Your Honor. That does not seem, unless it's a typo. You saying it was 3.9, maybe.
Go ahead.
That seems strange to me, Your Honor. I would concur with that. I don't know why it would take 40 miles for a local process server. The only thing I can conceive of is if there was a scheduled time to deliver it somewhere as set up between the defendant and the court officer, and perhaps he didn't, but obviously by the court officer did not say that, but I can't think of a reason. So we can either back those out, Your Honor, and then we can deal with the court officer on that, or we can resubmit an order or a new judgment with the new with the new figures. But as I understand it, if the court has no issue with the judgment amount, the contractual fees that are permitted under the contract, and just the filing fees, then we would accept that, Your Honor, and not waste the time. It doesn't seem like those amounts are an issue, unless Your Honor has any indication that those amounts are an issue here.
All right, well, no, I really, I think there was a question as to those amounts. So I guess I'll leave it in your court. If you want to resubmit an order with the corrected amounts, I think you're aware of the service miles traveled and the affidavit of service. If you resubmit with those fees looked at or changed, the court will entertain. And then, so I will wait to sign the default entry that was initially indicated. And then, Mr. Goss, I've got service perfected on this. If you want to make a motion to set aside or along those lines, that's all within your discretion. But I can't right now. My concern was with the statutory fees. It wasn't with the process serving method. The process serving method was affixed and was sent and did work this time. I don't know why it didn't work last time.
I don't either, but I
Right.
got it
So
in my mailbox.
It would be different if it was just the mailbox, but it was also pursuant to the process server. It was also affixed to the front of your door.
I never came home with nothing in front of my door.
All right.
All right.
So
it will read a default judgment with amended amounts after we have looked into the court officer issue. If the court officer issue is not something that is allowable, Your Honor, we will not seek it, and we will seek what is permitted under the statute.
But ain't this if they made up a lie, like I ain't gonna say she lied, but false paperwork saying 40 miles, ain't this like something like
Mr. Goss, you're more than willing to. You're more than Mr. Goss.
Lie was 40 miles.
Mr. Goss,
I don't live no 40 miles from no court.
Mr. Goss, you're more than able to file a motion to set aside. All right, but I see process as in two ways. The alternative process has worked, and you can file a motion in regards. I'm just taking this was all in order to take a look at some of the fees. So I'm going to indicate that the plaintiff and defendant were present. The hearing was held. Both appeared.
But like false,
and the
false
plaintiff is to resubmit the default judgments with after reviewing the statutory fees.
They can lie on their paperwork and it'd be okay. They can just resubmit some stuff. But I'm
Mr. Goss is claiming.
It's okay. Yes, it is. He even said it was false.
Mr. Goss.
I'm listening to the judge. Just go ahead and
Mr. Goss, you can talk all you want, and we'll just stop and we'll let you talk, and then we'll continue the hearing. Okay?
Yes, let's finish your hearing. I mean, it just seemed like you can say 40 miles and false, and that's some false statement, but then Uh, oh, you can resubmit it and it's okay, but then
Goss,
All right,
Mr.
Mr.
Goss,
sound
Goss,
like
do
a
you have
bunch of
anything to
bull
say
crap.
in order,
No,
we'll
yeah.
just wait patiently while you're talking and
But
then
I
we'll
waited
continue the
patiently
hearing.
for y'all to talk, and I ain't get to say nothing. But come on, let's continue.
I think you've said a
Let's
lot today,
continue.
Mr.
I ain't even
Goss.
say nothing. You
Okay,
asked me
what
one
would you like to
question.
say?
I don't
What
want
would
to
you
say
like to
nothing.
continue to say, sir?
I don't know why you ain't getting smart with him. He talked the whole time. Now you want to get smart with me, and I ain't said nothing. Come on,
Go
man.
ahead. Go ahead.
No, go
Go
ahead.
ahead, Mr.
Continue.
Goss.
Continue. That's just some bull crap. Come on,
All right.
continue. Because I
All
gotta
right.
continue.
All right. So I have that all parties appeared and that the default judgment will be resubmitted after reviewing the statutory fees. Is that correct, Mr. Biguccio?
that is correct, Your Honor. I will make a note for the court that service was proper. Mr. Goss has not answered the complaint, which was his
I
right.
ain't got no complaint.
And no false paperwork was submitted. And I'm not going to sit here and be accused of that. There was some question as to the mileage. It could be a
That's
simple
false.
typo. Mr.
Man,
Goss,
simple typos.
let me speak, please. And we will clear that up. Obviously, we don't want Mr. Goss to pay anything that he's not responsible to pay under his contract with Estera Credit Union. We are here today because he failed to meet his obligations under his contract with Estera Credit Union. And I want to make sure that Mr. Goss is aware of that. That's why we're here today, Mr. Goss, because you have not met your obligation. So we will resubmit a judgment, Your Honor. And if the court is inclined to enter it based on the submission, we will do so. If the court is inclined to set another hearing, I'm inclined to do that. If Mr. Goss wants to file a motion to set it aside, we will respond to that.
All right. All right. So anything else? So the court will await the order to be submitted with the edited or reviewed statutory fees. Anything else on record 2202-465, Mr. Buciccio? And I apologize if I've been butchering your name. It's Buciccio, correct?
It's Bequicchio, Your Honor, but that's close enough.
Buciccio.
And I
All
don't
right.
have.
All right. And Mr. Goss, you're welcome to file a motion to set aside the verdict, but we are finished with this hearing in 2202-465, unless you have anything else to say. You'll have to unmute yourself, sir.
How can I turn in paperwork if I don't even see how you? I don't got no paperwork to say how you submit paperwork.
All right.
This all I
Well,
got is. So how do you submit paperwork if I don't know how to do it? How you do it? This ain't no.
all right. You can contact our civil department and indicate that you want to set aside the verdict, and they'll go from there.
So just call downtown. Like,
Yeah, you'll call the 54A City of Lansing Civil Department and let them explain to you the process.
But you can explain it to him, right? All right.
The process. I just told you the process. The process is for you to set aside the verdict.
Okay, come on.
I don't know what else to tell you except to say that you
I
have to
don't know
set
why
aside
you
the
getting
verdict.
smart with me, and I ain't saying it. All I asked for a little help. You just what you getting smart with me for? And I'm not the one doing nothing but got some paperwork in the mail. What you getting smart with me for? I'm
All right.
here.
Well,
I'm paying the court. What you getting smart for?
You have your own conversation going there. So
you getting smart with me.
That's a good conversation. All right.
That you getting smart with me for no reason.
I'm telling you, sir, that
No,
you have
I'm asking
to
for
call
help
the
and you
civil.
getting smart. Come on, man.
All right, you have to call the civil department of the city of Lansing to set aside the verdict. That's the process. So that's all for the record in 2202-465. I thank everybody for their appearance today.
Thank you.
Maybe I was talking. I don't know. All right, Mr. Smith, you're here on the LAFQ case,
Correct, Your Honor.
and we're waiting for Mr. Standish. Is that correct?
We are. He had actually, this was a control date for documents. He had tendered the documents, and I'd emailed him saying that we didn't have to come today, but he emailed back and said he wanted to come to court today.
All right, I'll give him the allotted time period. And I've got one more case to call, and then we'll come back to that case.
Okay, thank you, Your Honor.
All right. And then, Mr. Is it Lejutro?
Good morning, Your Honor.
Good morning. Are you here for JGA Acquisitions?
That's correct.
And is Lejutro correct, the correct pronunciation?
It's low utro.
Glowutro. Okay. And then Mr. Narrett, you're here for Kimberly Fox?
That's correct, Your Honor.
Oh. All right, let's go ahead and call that case. Mr. Zloyutro, have you had the opportunity to speak? I'll go ahead and call the case, but have you spoken with Mr. Narrett
I have not.
case?
No, Your Honor.
I always do that at pretrial. I have a pretrial statement we can fill out, or the parties, since they're both represented, could both fill out a pretrial statement on their own after a meeting. But I'll go ahead and call the case, and then we'll go from there. So we're on the record in 23-01102. That is JGA Acquisitions versus Kimberly Fox. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Daniel Zliutro, P85174 for the plaintiff.
Your Honor, Attorney Frank Narrett for the defendant in this matter. I don't know why my video isn't working today, but I'm having trouble with that.
All right, we can hear you just fine, so I think we're all set. And I can attest it is you, Mr. Narrett.
Yes, sir.
So this is the time set for a pretrial in the matter. Mr. Zalutro and Mr. Narrett, we can fill out the pretrial form, or if you meet, you can send in a pretrial form on your own. But I would give you the opportunity to meet in a breakout room if you chose to.
I'm okay with that. It's up to Attorney Narrett on that.
Mr. Narrett, would you be amenable to meeting with Mr. Zalutro in a breakout room in order to discuss some of the pretrial matters? And we can either put it on the record, the pretrial statement, or the parties can submit a pretrial statement.
Yeah, I'd like a few minutes in a breakout room with counsel. Your
All
Honor.
right. All right. We'll have you both placed in room 1. So you should get a prompt or be taken to room 1.
Thank you, Your Honor.
You're welcome. All right, so we're back on the record in docket 23-01102. And Mr. Narrett and Mr. Zalutro, did you have the opportunity to speak in a breakout room?
Yes, Your Honor. The parties spoke and we decided to fill out a pretrial statement on our own and send it into the court.
All right, Mr. Narrett, is that fair? So that I can indicate that the parties met and that you're gonna follow up with a pretrial statement?
That's correct, Your Honor. Counsel's going to draft something. He'll email it to me. We'll get together on it. We'll get a joint pretrial statement filed with the court.
All right, perfect. So with that, anything else on docket 23-01102? The court will await the pretrial statement to come in from the parties. Anything else of Mr. Zalutro or Mr. Narrett?
One quick brief question, Your Honor. This is actually my
Sure.
first time in your court particularly. Is your pretrial statement available on the court's website or is that sent to me?
Yeah, I believe it is. I believe
Okay.
it's available on the court's website. If there's any problem in that regard, just email my staff and we can send you out a copy of our pretrial statement. We can scan a copy to you. It's
Sounds
just
great.
a
Thank you so
one-page
much.
document. Okay.
Thank you.
All right. Any questions, Mr. Narrett?
Nothing further on this matter, Your Honor. Thank you very kindly.
All right. That's all for the record in 23-01102. Thank you for your appearances today.
Thank you, Your
Yes.
Honor.
All right, Mr. Smith, let's go ahead and call your case on Mr. Standish. And you indicated that we expected Mr. Standish to come, but you'd already told him that that his presence wasn't necessary since he provided the documentation that was necessary. Is that my understanding?
I did. I communicated that to him yesterday, but then he emailed me and said that he still wanted to come to court today. He did just email me asking for the Zoom number. I immediately responded with this court's Zoom. So he may be trying to Zoom in momentarily.
He might be here right now. I just admitted somebody to the courtroom. All right. And sir, are you Adam Standish? Oh, it's not connected to audio yet. Sir, are you Adam Standish? I didn't hear that, sir. Are you Adam Standish? Oh, your audio's not working.
Can you hear me now?
I can. Sir, are you Adam Standish?
Yes, sir.
All right. We're on the record in docket 1602495. That is LAFQ versus Adam Standish. Will the parties please introduce themselves for the record? Mr. Smith.
For plaintiff LAFQ, Tim Smith, P48259. Good morning, Your Honor.
And sir, you are Adam Standish, is that correct?
Yes.
All right, this is the time set. This was used for a control date to get some information of Mr. Smith concerning discovery. Mr. Smith, how are we proceeding today?
You're correct, Your Honor. This was a control date. There were certain documents that were responsive to your subpoena related to employment and banking information. The defendant did provide those to me as the court ordered via subpoena. I advised him yesterday that there was no need to appear. He had emailed back indicating he wanted to come to court today, and I don't know why. Perhaps we could have Mr. Standish explain why we're here today.
Oh,
All
that'd
right,
be
so-
easy to explain it.
All right, so Mr. Standish, according to Mr. Smith, the discovery has been provided in this control date. Is there any record you wanted to make concerning your appearance today?
Yes, sir. I'm disputing the amount. The full amount of the loan was for the amount that you see. When they repossessed the truck, they sold it. So the amount that they sold the truck for was supposed to come off of my loan amount. And they are doing shady business deals by still making me pay for the full amount of the truck when they sold it for $8,000, which was supposed to come off of my loan.
All right, so this is, so Mr. Smith, has a pretrial statement been filled out in this form?
No, this suit actually was filed in 2016, Your Honor.
All
Defendant
right,
was served. He failed to file an answer. He failed to appear. He failed to
They
dispute any
failed to
aspect.
notify me, properly notify me of this court date or proceedings in any way, shape, or form. They did not email me about the loan. They did not email me about me going to court or taking care of it. At the time, I was homeless, living on the street. So they didn't properly go through any channels to notify me of anything. So for them to say that they went through the proper channels to notify me about this whole situation is actually disrespectful to me.
all right, Mr. Standish, I don't know what was done in 2016, but there are various ways to provide notice. So,
Right,
you know,
they didn't provide any of
well,
them.
you may not have, there's various ways to provide notice, and we're talking about something that happened over 5 years ago. So, but Mr.
Right.
Smith, you have the discovery, and should our next hearing be a pretrial on this or an additional, or
But
oh, it's already been done because it was a 2016 case. Yeah.
we have a judgment, Your Honor. For the record, there's an affidavit in the court file from the court officer
Okay.
who personally served him July 28, 2016 at 6:45 p.m. at 1101 Latham Street, Lansing, Michigan. So that's really not before the
They
court.
have it on file as a mailing
Standish?
address.
Mr. Standish, I'm speaking. And so at this point,
you-
Your Honor,
I don't care.
Mr. Standish, Mr. Standish, you'll get a chance to talk all you want. I'm going to hear from Mr. Smith, and then I'll hear from yourself. The purpose of this hearing is over, but I'm going to allow Mr. Smith to talk and then you to talk, and then we'll wrap things up. So go ahead, Mr. Smith.
What brings us here today, Your Honor, was a creditor examination. The examination is complete. Documents have been produced. So what we're here for today is done and complete. There's no further issue as far as the docket is concerned as it relates to this matter.
All right. Mr. Standish, you at this time or sometime can file a motion to set aside a default out of 2016. I think your time period is well past, but I mean, but you have options available to you. The whole purpose of this hearing was to make sure that Mr. Smith had the documentation that's been provided, and that's all we're meeting for today. That's the whole purpose of this meeting. Is there anything else you wanted to place on the record? I know you have objections to the nature of some of this coming out of 2016. But the whole purpose of today was to make sure that information was provided to Mr. Smith in regards to this file.
Okay, so we still have a trial coming up?
No, there's been a judgment already. There's a judgment in the file coming out of, I would say 2016 sometime. There's a default judgment out of November 28th, 2016.
Right. And there's no understanding by the courts that I was homeless living on the street, and there was no way for them to properly notify me.
You had an address at the time, and you can make
address. It was a mailing address submitted through them,
Right.
so it's not an address.
I understand. I am Mr. Standish. I'm understanding your objection to the nature of the default judgment in 2016. You can go through any legal recourse you need and talk to the civil department about any questions you might have in regards to that default. But the default is out of 2016, and it did have proper notice at that time.
No, how do I properly know?
I'm not going to relitigate what happened in 2016 at this point. If you choose to,
It was shady. It was shady,
okay.
Your Honor.
If you choose to, you can follow whatever variables and whatever whatever options are available to you. But this default judgment's out of 2016. I don't know anything about the case. I do know that the purpose of this hearing is all set.
So it's just said and done. They're gonna start garnishing my wages and that's it.
I don't know what your options, Mr. Standish, I don't know what your options are, but if you want to seek counsel or call the civil department or go online and see what options are available to you, those are all options that are available out of November of 2016, which is the date on the default judgment.
Fuck this country.
All right. Well, thank you for that. All right, Mr. Smith, anything else on 1602495?
Nothing, Your Honor.
All right, thank you. That's all for the record in this file.
Yeah, shady business people. Oh.
And we can mute Mr. Smith on his commentary. We're all set. Thank you for your appearance today, Mr. Smith.
Thanks, Judge. We'll see you.
Did you just remove it? Did that feel good?
00614. That's RPM Auto Sales versus Devorah Wilson. Will the parties please introduce themselves for the record from the plaintiff?
Yes, good morning, Your Honor. Thank you. Brent Credible appearing on behalf of Plaintiff RPM Auto Sales Inc. P 75845.
And sir, you are, and pronounce, correct me if, Devorah Wilson?
It can be pronounced that way, but it can be Devoyer or Devorio.
Devoyer.
Yeah.
Okay.
I prefer Devoyer.
Okay, Devoyer Wilson. All right, thank you. All right, this is the time set for a motion, but I know the parties have had some time to talk to one another. Mr. Craddock, and it's Craddockville.
It probably is actually, but that's not how my family pronounces
Okay.
it. It's just a silent CH basically.
Okay, so it's Craddockville.
Credible. Yep.
Okay. How are we proceeding today?
I think we have to proceed with the hearing, Your Honor. We did have a chance to discuss everything. I provided Mr. Wilson with a copy of the lawsuit and all the attachments. And, you know, we kind of talked about it a little bit. I don't think that we necessarily have an agreement between the two of us on any kind of, I did, you know, discuss the possibility of a consent judgment or payment arrangement or what have you. We're not there yet. I do think at this time we just need to proceed with his.
All right, so this is based on Mr. Wilson's motion to set aside the default, and so my indication on your motion to set aside is my understanding, and then you can go ahead and state whatever you want to, is that you indicated that you had switched addresses so you didn't get noticed. And that was the initial order regarding alternate service motion that I signed was made for 1143 West Maple Street. And that was based on an affidavit of due diligence of trying to serve you at West 1143 West Maple Street. And there was 4 attempts to serve at that time, and you were unable to be served on that. And then so the motion was made, and then there was that was made to that Maple Street address with which is where, and then there was a second summons of April 26th concerning this event. Now your indication is that you didn't live at that address, is that correct? Okay. And what was the date of your new address that you were no longer living at that Maple Street address?
I had moved from there on May 12th.
So what date?
May 12th.
May 12th. Okay. So I have the second service tacked as of, it was tacked as of first on May 12th. So it was tacked on that date, on the May 12th date.
It was mailed on the 12th, Your Honor, and I think
Okay.
it was maybe tacked a week later. Well, when we talked at the last hearing, I had more or less
Right.
not admitted, but you know, yeah, it sounds like if what
It
he said
could have-
about his dates are true, then
It could
was
have happened.
that day.
Right.
And I know, and I'm not trying to speak out of turn. I know we also talked about this last time, but I did. Mr. Wilson did contact my office May 31st.
Okay.
And I personally spoke to him. You know, and I kind of tried to offer a resolution. He didn't really want to hear it, and I don't believe he had the paperwork in front of him. He just had our information off of whatever was posted at that property. So I guess my only point in saying is that he was aware that there was a lawsuit as early as May 31st or possibly earlier. I don't know.
All right. So the indication is that, but in notice of the actual hearing date that was the subject of default, that's unknown.
There wouldn't have been a hearing.
Yeah, it wouldn't have been a hearing date. Right.
Right. Yeah. His notice of rights, I guess, on the summons, he was not in possession.
And then, so the second aspect to that is there's an indication that a meritorious defense for the claim, whether you have a meritorious, and you indicated the truck was paid because I had lost my job and called them to pick it up since since I almost had been 5 years. And so you were questioning the,
Yeah, like the statute of limitation.
all right.
Like,
And so, so so your indication is that you're not disputing, well, you're not disputing that you entered into a contract for the truck.
correct.
All right.
I know I signed up for
Your
it.
indication is that the truck was paid off.
No, not that it was totally paid off. Like I'm supposed to pay payments on it.
Okay.
But if I null and void, like I can't pay for this truck, and I discuss with you like the reasoning behind it, why I can't pay for this truck, and you come get it. I feel like me as a person, if nothing else has been discussed, I feel like it's null and void, like it's over and done with.
All
Like
right.
that's behind me. Like
All right. Mr. Cradical, your response to the second aspect of the motion, which
Yeah.
is the meritorious claim, which I probably is what we're here on today, I think.
Yes, Your Honor. I mean, I just brought up the stuff about the
Right.
cause, just, in due form. So regarding the meritorious defense, I mean, and again, me and Mr. Wilson spoke about this 10 minutes ago. It sounds to me as though he feels like gave the vehicle back. And yes, I don't disagree with any of the facts. Kind of he's laid them out regarding the return of the vehicle. It sounded like there was a period of time where he was not making payments. He contacted my client, said, "I can't afford this anymore. Please come pick it up." They did so, and unfortunately, there was a relatively high balance remaining on the vehicle as few or no payments were made towards the balance. And then they ended up selling it for $850, which is to me is salvage value. My client has no interest in salvaging a vehicle that they could sell on their lot for much more money. And obviously, Mr. Wilson would have been given credit for much more had they done so. So I'm not a car guy. I don't know what goes into that decision making exactly. But they saw fit to mitigate by salvaging, and so it leaves a balance. Mr. Wilson doesn't feel like he should have to pay that balance, and I guess I don't agree based on the contract that he signed and my familiarity with the law.
Right. All right. So I think I understand the nature of the hearing. I would indicate that the summons and complaint, as far as the failure to appear, and that you did not answer, we would agree is questionable. Whether you have a meritorious claim, I think the numbers stand for what the numbers are. I don't think that changes the fact that you don't have a meritorious claim. What you're indicating is you don't feel it's right for them to be able to go after you for the car's full value because you made some payments, and they've of course mitigated that from the payment because they sold it at a salvage value, but your name is still on the contract. So as in regards to meritorious defense, I don't believe you have a meritorious defense under the law. You may have one by what you're arguing, but the law doesn't look at it the way that you're looking at it.
it's still a statute one. Like, I know it's been 6 years, or like it's a statute on it.
This started as so how do you respond to the claim that there's such a delay that the contract was signed in 2017?
Yes, Your Honor.
Yeah.
So the contract was signed in 2017, and the default occurred later in 2017. The reason for the delay and the reason that the lawsuit was not summons was not issued until March of 2023, as I explained to Mr. Wilson when we first received this file from our client quite a while ago, back in 2018. But we look up a best address. I mean, we're constantly trying to find the best address. Obviously, that's also an issue here in this time. But we found that he lived. I want to say, MS is that Missouri or Mississippi? Mississippi. So at the time, he was living in Mississippi. So in my office, that goes into it gets coded a certain way. We review it every so often to see if there's a new address that is located in the state of Michigan that would allow us to proceed. We found that address when we found it. I want to say probably towards the beginning of 2023, and therefore that is when suit was filed. Yes, I mean we found the address March 7th of him being in Michigan. I'm not saying that that's when he moved back. That's when we discovered that. The lawsuit was filed very shortly thereafter. I believe we are within the statute of limitations for breach of contract.
Yeah, you are within the statutory limitations of breach of contract. So I am going to deny the motion. To set aside the default judgment. And we'll do it. We'll do an. I don't know if you have an order to that effect. I don't have one in the file, but we can do an order to that effect.
I don't.
Okay.
Whatever the court would like.
All right. Why don't you submit an order to deny the motion since we had a hearing on it?
Absolutely.
So
then under the 7-day rule.
I don't have a problem with you doing it under the 7-day rule. What that means is you're still at that Riverview Avenue address. All right. So that means that once it's emailed to the court, you'll get it. You'll get that order, and it'll give you 7 days to object to the order. Okay, to the nature of the order. But for the meritorious defense claim, which is the portion that is the main portion of this, I'm going to deny your motion and affidavit to set aside the default and allow the default judgment to stand as ordered. And then council will follow up with an order. Order to,
Yes, Your Honor, and I'll make
order
sure you
to
get the copy
follow.
of that as well.
All right. So, Mr. Wilson, do you have any questions of me today? I've denied your motion, and the orders going to be to follow to that Riverview address. It was denied on the second part, really, which is the meritorious claim. We did not deny it on your failure to appear. Okay, sir? All right. Anything else for 23-00614, Mr. Cradaville?
No, Your Honor.
All right, Mr. Wilson, you're all set. Thank you for your appearance today.
Thank you, Your Honor.
And I just placed in the file order to follow.
Gotcha,
Okay.
thank you. I was trying to find a business card. Call me, and it turns out I don't have any. I guess I'm out of practice with going to actual court.
Right. That's a good or bad thing, depending.
I mean, I like some things about. I like being in court. It's not the being in court. It's the to and from.